more confusion to practitioners. I have two trial court decisions I want to talk about briefly, and these are at the end of your materials. The first one is published in your materials. The second one is available on our website at gaylordmerlin.com. I'll talk about that in just a second. This first one is a county case coming out of Marion County. This dealt with the changes to the eminent domain statute. There were a series of changes to all the eminent domain statutes as a result of the Kelo decision that came out a few years ago. And one of the changes that came down was a change to Chapter 172.02, which is the statute that authorizes counties to condemn property. And in this decision, the court points out that the legislature added the word "the" before parcel. And by adding the word "the" owners argued, well, that the parcel, the owners argued that you have to pass a resolution for each parcel that you want to condemn. You can no longer pass one resolution to condemn 50 parcels. You have to pass 50 resolutions to condemn 50 parcels. And the trial court in this decision agreed with that argument, and the authority for that that Judge Stingbush cited is in there and in the decision. And he said essentially that it was fatally defective, where the county was seeking to take 10 properties. I give you this decision because it's an interesting argument that's being made, that was made by the owners in that case. I know that Sherry Hopkins, I think, has dealt with that issue, and she got a converse ruling from the trial judge. So you can talk to Sherry about that in her case in Osceola County. And it wouldn't surprise me if other lawyers...
Oh, it's actually the word "a" as opposed to "the."
Oh, it's A, I'm sorry. A different article. Same effect, though.
I had the same thing brought up with Pinellas, and Judge Bair ruled exactly the opposite also.
So there may be some appellate authority about this at some point in the future. In this case, the county chose not to appeal and just proceeded with filing new resolutions. The next case that's not in your materials, I was just provided about a week ago. This is not a reported circuit court decision. Again, you can get a copy of the decision on our website at gaylordmerlin.com. It's a 2-page decision from a circuit court judge in Volusia County. Some owners, Larry and Lauren Hiss, entered into negotiations with the county after the county had sent out what's called a notice that they were going to condemn property. The owner hired experts, hired a lawyer, incurred all sorts of attorney's fees and experts' fees, and negotiated with the county. However, the negotiations did not result in an agreement, and the county ended up voiding not just the parcels, but the whole project. And the owners were then left with no way to recover their attorney's fees or experts' fees and costs. They then brought a suit against Volusia County and said, well, look, you provided us written notice that you were going to take our property and that we were entitled to reimbursement of fees and costs. We incurred all these fees and costs in reliance on your notice and negotiated with you, but then you abandoned it, no property was taken, and you haven't paid our fees and costs. The owner brought 2 causes of action, one for promissory estoppel, and the other one was brought for attorney's fees and costs under 73091. The court said you do have a cause of action for promissory estoppel. You meet all the requirements for promissory estoppel. However, your claim for promissory estoppel is barred by the doctrine of sovereign immunity. I don't really understand it, but that's what the court decided, is that you can have, you basically said the counties are sovereignly immune from any kind of promissory estoppel with that kind of ruling. The court also correctly pointed out that there is no legislative authority for fees and costs where there has been no taking of property. And that's been a part of the law for a number of years, where there is no taking property, you cannot recover fees and costs under the statute. This is the first time that a court has said you cannot recover fees and costs for promissory estoppel. So the Judge Rouse dismissed that complaint with prejudice and dismissed the action. I know that the lawyer on this case, John Upchurch, has another case on appeal in front of the 50CA on similar facts. I don't know what the status is of that decision. I don't believe that this case will be appealed. But this is a gap in the current eminent domain statutes that were passed back in 1999. Those amendments in 1999 were passed by then Governor Jeb Bush to encourage pre-suit settlement and negotiation. And what having the opposite effect. And John Church has told me that he is not going to negotiate with Volusia County until they file a lawsuit, that his clients felt like they were dealt with in bad faith, and that they feel like the whole purpose of the statute has kind of been thwarted with this action and this decision. So I have not seen this happen by other entities myself. I know that it's part of the Department of Transportation's right-of-way manual, that if they void a taking, that they will still pay your fees and costs. And that's part of their policy under their right-of-way manual. I don't think there's any statute on that. I'm not aware of any statute on that, but it's part of their right-of-way manual. But there is no such provision in the Volusia County right-of-way. But that is a decision, again, that's available on our website. And I think it's going to be put under the section of news under GaylordMerlin.com. So with that, thank you all for listening to the Case Law Overview, and I hope you have a good rest of the day and enjoy all the rest of our speakers. Well, we've got